Welcome, everyone, to this LCR webinar on understanding EB-5 project filings and how expedited I-956F filings impact investors. That's our subject today. We are excited to be talking about this because everyone understands when they're going through the EB-5 process, the importance of the project they choose, both from a security of capital as well as an immigration benefit. And since the Reform and Integrity Act in 2022, there has been changes in how USCIS handles its project filings. And so it's an opportune time for us to bring together our expert panel and talk through this. I'm happy to say Ron Klaskow, for folks who are in the EB-5 industry, needs no introduction, but we know that of the I think 450 people that registered for this event today, a number of you are investors and probably newer to the to EB-5. Ron has been working in the industry since the very beginning and is a very well-known figure from both speaking at industry events, working directly with his team, with investors, and also representing the industry in its conversations with the U.S. government, with USCIS. So Ron, thank you for being here.
It's my pleasure. Thank you very much, John.
And we also have Chai Carve, who's part of the LCR team, and she's going to run through the questions. She's been working with quite a few investors. A number of you joining today are probably working with her daily. In terms of taking these questions. And it's one of the reasons we put together this webinar, because it really is a very for lack of a better word, hot subject that people want to learn about. And being able to bring Ron in and for Chai to be able to ask the questions in terms of what investors have is a real opportunity. So we're happy to do that. And of course, we're making a recording of this and we will share that out with all of the registrations. Thank you for taking time on what is a global holiday week. It's the end of Lunar New Year for folks in Asia. It is the end of Carnival Week for everyone in Brazil. And of course, it's the Friday before a long weekend here in the US for President's Day. But I can see that the room has filled out nicely. We've got a good number of people. Thank you for taking the time to join us. I do need to run through a quick disclaimer and then a little bit of housekeeping pieces, and then I'm going to hand it over to Chai to go through the three areas we want to discuss, which is the project briefing, the 956F, how the government reviews them, and if they are frequently approved, denied, or the process of that. And then last, what does it mean to be an expedited project? And Ron has worked with expedited projects from before the Reform and Integrity Act and even now today. So the disclaimer really quickly, it's not a surprise that this presentation does not constitute legal immigration advice. Ron is here, he is an immigration attorney. However, you're not in a client attorney relationship, so this is not advice. If you do want legal advice, obviously you need to enter into that contractual relationship. And obviously Klaskow is an excellent firm to do that if you so choose. This presentation also doesn't constitute an offer to sell securities. We are talking about EB-5 projects and investing in them, but this presentation is about the program. If you're interested in seeing project investment documents, we'd ask you to contact us directly. We need to confirm that you're an accredited investor, particularly if you're in the US, and then we can then focus the conversation on your needs and your family's needs. So on that note, Chai, one other thing I'd like to add. If you have questions during the conversation, feel free to use the Q&A button. It's in the Zoom software. We can gather those up. Chai can try to work them into the conversation with Ron, or we'll also, assuming we have time at the end, we can run through them there. So the Q&A button is just underneath on the Zoom software, and that's the best place to drop those questions in. So Chai, over to you. The I-956F filing, can you demystify it?
Yes, I cannot, but Ron can for us. This afternoon came out of this question that I get asked every single time, and I really wanted to have an opportunity to educate our prospective investors. And when I thought of who I wanted to invite, Ron Costco obviously was my first choice, and he obliged us. So I'm very thankful. Welcome, Ron, and thank you very much. So I'm just going to really just start with the basic question: is what is 956F application? When
Sure.
does it get filed, and how long does it take to be approved?
Well, there's a few questions in there, but let's take a shot at it.
Okay.
The I-956F is the project approval application. It used to be called, before the new law, before the Reform and Integrity Act, it used to be the exemplar petition. But now it's called the I-956F project approval application. And the project approval application has everything about the project necessary to explain to the Immigration Service why the project should be approved. The important thing about timing is that it must be filed by the regional center before any investor can invest in the project, but it does not have to be approved. So in almost all cases, the I-956F won't be approved when investors invest, but we do have to prove that it has been filed. The I-956F has all of the securities documents, the private placement memorandum, the offering documents. It has the EB-5 business plan in it. It has the economic report showing job creation in it. So everything we need to prove that it's an approvable project is in the application. And when we're putting it together, we work with securities counsel, business plan writer, economist in putting this together. From the investor's point of view, there's a big change. It used to be, before the Reform and Integrity Act, when you filed an I-526 petition, you had to include all of the project documents, hundreds and hundreds and sometimes 1,000 or more pages of project documents in every investor's application. Under the new law, that is no longer how it works. Now, all you need to do is submit the receipt notice to prove that the project you invested in has a filed I-956F, and the only thing the investor needs to include in the filing is documentation of the investor's source and path of funds. So, Chad, there were a few questions you asked me. I hope that answered at least some of them.
It pretty much did. I remember in 2019 seeing a picture of a truck having boxes full of petitions. So I guess we're saving some trees too by doing this process now. So that's
It actually makes a lot of sense, Chai. It's something we had advocated. John mentioned that I've been in positions to advocate on behalf of the EB-5 industry to the government, and this is something we had suggested many years ago, and I think it's a much better system. And what was critical, when we were dealing with the new law, it appeared they were going to require this to be approved first, but under the new law, they do not require it to be approved, just filed. So I think they've got that right.
And in the old days, the exemplar approval was also optional, right? You didn't always have to get it. Is that correct?
Oh, yeah, you definitely didn't have to get it. The difference, Chai, is under the old rules, the filing of the exemplar was completely optional. You didn't have to do it at all. Under the new rules, you must file the I-956F before the investors can file petitions.
So effectively, there's a project review, and then there's an individual review. So the 956F, which we're talking about, is all the information on the project, and for the individual, it's source of funds and immigration history and family.
Exactly, yeah.
Excellent.
So Ron, my follow-up question was, is there a difference between 956 filed for rural or high unemployment TEA, or they're all pretty much the same?
So what we need to file for a project, whether it's rural or high unemployment TEA or not in a TEA at all, what we need to file is the same. The difference is that under the new law, the Immigration Service is required to do what's called priority processing for rural area cases. Now, priority processing is not defined. It doesn't say it must be within X number of days. but we have seen that the Immigration Service acts quicker on rural project I-956Fs than on others. It seems like the high unemployment TEA projects are worked on quicker than projects that are not in a TEA at all.
Okay, that's a very good thing to know. My next question is, in what scenario would you see a 956 being denied? Should investors worry about it because they're interested in many projects that they want to invest, but are prevented because these projects don't yet have the 956 approval?
Yeah. So, and we're just to be clear, we're talking about the 956F.
If that
Which
is correct, the
the project
956
approval
SW.
application.
Yes.
So there are a lot of reasons why it could be denied. I mean, honestly, it's my job, and you know, I've worked with LCR, and it's my job to put together the project documents and be able to identify problems in advance, so that hopefully we won't have problems getting approvals. But the kinds of things that we see for project denials might be, for example, if the capital stack, if you present a situation saying the cost of this project is $50 million, and when you look at the capital stack, it appears that we can't account for a full $50 million. They can say the project is speculative. It's not clear if you'll ever get the construction loan that you hope you're going to get, that's going to be 30 million of the 50 million. That can be an issue. A hot issue right now, Chai, is bridge financing. And the concept here is that in many cases, investments are made into projects where the project is already ongoing and the jobs have already been created based on equity put in by the developer, based on loan proceeds. And now the investor wants to come in and get credit for the jobs that were created before the investor made the investment. And this can be complicated, but if it's structured properly, it definitely can be approved. And if it's not structured properly, it can be a very common reason for a project denial. One of the other, there's a lot of reasons why something could be denied. Another hot issue these days is there's part of the process of filing the I-956F is that the people at the regional center and the project who are actively involved in decision-making have to file a form. It's called an I-956H. And we're still at the early stages of this new law, and it's not clear who needs to do this. And the Immigration Service has a very, very, very expansive view of who needs to file these I-956Hs. And most of my clients believe that the people who they want to file are not in positions of authority. So that's an issue we're dealing with. I don't know how many of these you want me to go into, but that would be a few examples of what we see these days of, you know, issues that arise at the project approval level.
I'm really glad you addressed the bridge financing, because part of my pitch always is that you want to invest in a project that has ongoing construction and that does have a backup bridge financing in case EB-5 financing doesn't come in. And it's also the most frequently asked question by most of the investors, because it gives them comfort that the project would be completed. So it's a really important question for my investors, and I'm glad we addressed that.
Yeah, we actually spend a lot of time with our regional center and developer clients on that issue. And on the Immigration Service has in their own mind certain things they want to see. They want to see that either the loan or the equity was both short-term and temporary. That's two different concepts. and also that there was an intention from the beginning that the equity or the debt is intended to be replaced by something, by EB-5 money or something else. So when we structure the project, we make sure we deal with those issues.
Yeah, I had a very smart investor ask me that question just this morning, so I'm really glad we addressed that. I'm going to go on to my next question, and you've already said this, but I'm going to ask it anyway just to clarify, and that is, must the 956F project application be approved before investors can file their individual I-526E applications?
Yeah, and the short answer is no. It must be filed, but it does not need to be approved.
Okay. And then my next question is, do you believe that the 956F project application has to be approved before USCIS will process the I-526E applications?
So I don't think I've heard the Immigration Service address this, and the new law doesn't address it, but as a practical matter, I think the answer is yes. From what we see, the order of things will be the I-956F gets filed, then the investors file the 526Es, and before the Immigration Service approves the 526Es, they approve the I-956F. That seems to be the order of things.
Okay, I'm glad we clarified that. My next question is an RFE for a 956F project, do you see them often? Are they common? And then I have always said that an RFE is not a bad thing because it always produces if you answer it correctly, it produces a positive outcome. So could you talk a little bit about that?
Yeah, an RFE doesn't concern us very much. That yes, a lot of projects get RFEs. It's not, oh my God, we have an RFE, something horrible is happening. It's basically saying, it can be very, very, very benign. Basically, they want certain things clarified before they approve it. Sometimes it's longer and there are more issues to address. But we've certainly seen many, many, many RFEs over the years, and in almost every case, we're able to resolve the issues raised in the RFE and get the approval.
Oh, that's very, very assuring to know. I wanted to now move on to the expedited approval process. We at LCR have applied for one for our rural project, the U.S. Strategic Metals, and I wanted you to describe what that means and how you handled it for us. How was the process?
Sure. So the Immigration Service has the ability, but not the obligation, to expedite a project. They do it very, very rarely. We have had some success in getting expedites for a number of our clients, but it's still rare. The basis is usually something relating to the national interest. And when we do these, we often try to get a government agent, rather than us saying, I'm Ron Klasko, trust me, this isn't a national interest. We want to get people in the government saying, we're with the Department of Agriculture, or we're with the Department of Energy, and we can explain to you why this is in the national interest. So when we do that, we've had some success in getting expedites. So what an expedite means has changed somewhat over the years. So under the old law, before the Reform and Integrity Act, it was not unusual that when we got an expedite of a project, the Immigration Service also agreed to expedite the I-526s of all of the investors in that project, present or future. Before the RIA came, they stopped doing that, and they said, well, we will not expedite anything that's not in front of us. So if there's an I-956F in front of us, we will consider whether to expedite it, but we will not expedite all of the petitions that may or may not be filed in the future. So what the expedite means is that the government has committed to taking the I-956F out of order and adjudicating it more quickly than they adjudicate other cases because of the national interest. Now, again, that doesn't mean that all investors will be expedited, but it does mean that investors, if they wish to, can choose to request that their petition be expedited, perhaps for some of the same reasons that the project was expedited. So, you know, it's possible to prepare something for investors where they can, at the same time as they file the I-526E, say, please expedite the project for the reasons specified in the expedite, please expedite my petition for the reasons that were explained in the expedite request of the project.
That was very good. I think I have asked most of the questions I wanted to ask. I'm going to I'm opening the floor up for
We-
questions, starting with my first question, which is, with the I-526 petition, in your opinion, are there any project documents that need to be filed at all?
No, well, first of all, you said, so let me make a clarification. Under the new law, the I-526 is for a direct EB-5. The I-526E is for a regional center EB-5. So with a direct EB-5, you file all the project documents. With a regional center application, there should be no reason for an investor to file any project documents. All that's needed is the receipt for the I-956F filing.
Ron, thank you about that. And I do apologize. This EDF is driving me crazy. And
They didn't make it easy, did they, Shar?
yes, it was definitely
It ties back to the sections of the legislation. Can I jump in, Chai? Because I know you talked about processing time, Ron, and USCIS published that the typical time to process the 956F, so the project briefing, the one we're talking about, is about 12, 13 months. Are you seeing that's typical the processing time there?
Yeah, well, for non-rural projects and high unemployment TEA projects, I would say 12 to 16 months seems to be about normal. John, you've been dealing with immigration as I have long enough to know that you know, it's not like a train in Japan that you set your clock by. You know, these times are inconsistent and they change, but 12 to 16 months seems to be a range that we've seen in recent months.
And then on the rural ones, you're seeing a shorter time frame.
Yeah, definitely a shorter time, sometimes a lot shorter time, John.
And then and if I understand it correctly, with an expedite, if they approve it, they're saying that they'll do that turnaround in a month. Is that accurate? Do they
Well,
actually?
they're not committing to that,
Okay.
but you know, if they agree to expedite, we would not be surprised by a decision in, let's say, a month or two, either a month or two from the filing or a month or two from any RFE.
Excellent. And of course, if the F's been approved on any project, then you know that your petition won't have any issues with the project.
so
Your petition
if-
comes down to your personal source of funds and immigration history.
Exactly right, John. So if I'm an investor, the fact that there's an approved I-956F, you know, tells me that for immigration purposes, you know, I've got a good, should have a strong petition as long as my source and path of funds are good.
Yeah, huge comfort there. Sorry, Chai.
No worries. I have the next question goes to, does expedite processing guarantee a quicker adjudication timeline as compared to a regular priority processing for a rural project? And Ron, you just answered that. And I think, John, you were meaning to ask the same question, correct?
Yeah, it's those timelines there. Yep.
I don't see a lot of you did ask the timeline question too, so I'm not seeing a lot more, but since I could do like 100 questions with Ron, but promised I promised everybody I won't. But Ron, yeah, I would like you to also help some of my investors understand a little bit of timing, right? So now everybody's trying to race against April 1's fee increase. And what would your advice be for them? You know, how soon should they be making decisions? How soon, maybe a little bit of your perspective on what it really takes to put AI 526 petition together, you know, because you don't want them knocking on your door on March 15th wanting to get their petition in, you know, so some wise words for them and maybe explain to them how they need to be on top of things.
Yeah, so, obviously there's huge advantage in filing before April 1st because of the very, very large fee increase. And, different cases take different amounts of time to put together, but a lot of times, especially if you have multiple sources of funds, it can take a while to put together a strong case. And the more time we as attorneys have, the better the chance we're going to be able to file a case that's not going to get an RFE. If we need to do it at the last minute, we might be able to do it, but with a much greater chance it's not going to be as complete. And you need to understand that, law firms like ours, we represent a lot of investors. And, we really can't, in good faith, our commitment is to our investor clients. And if an investor comes along on March 22nd and says, I need to file in a week, we really can't guarantee that we can do that because we have a commitment to the people who've retained us earlier. So the short answer is, if about $8,000 is a meaningful number, which it is to most people, and that's the amount of the increase for the filing fee, then you should be expediting your decision on a project and your retention of an immigration lawyer to work on your source and path of funds and as far in advance of April 1st as possible.
All right, that makes sense. I've been telling in my experience, I see it easily takes us 10 days between you and us for the documents to go back and forth to get the execution package to you and for you to really just send it out, right? At least a 10-day, because a lot of my investors feel like, oh, well, I funded, now I should be filed the next day, and it just doesn't happen that way. You know, a lot of receipts go back and forth, and
investors need to understand that the immigration service is incredibly meticulous and detail oriented on source and path of funds. And what may seem straightforward and simple, of course, all my money is legal, it's in this bank account, but how did it get to the bank account? And if it involved, well, I sold some property. Well, how did you make the money 10 years ago to be able to buy the property in the first place? And it can be very, very document and time intensive. And if you want your case filed as a strong case, you want to give your lawyer some time to prepare everything.
And really not make any administrative mistakes, right? Because those are the costliest, actually. Everybody worries about RFEs, but RFEs give you a chance to respond and correct, some don't. So everybody wants to be really meticulous about that. Moving forward, and this is a question that is definitely a product of the new law, but partial investments. What is your perspective on partial investments?
Yeah, I'm not a big fan. When my clients talk to me about this, I say, yes, it can be approved. I think it increases the risks. So when you're doing a partial investment, you still have to show that there's a concept, Shai, called approvable when filed. You have to show that your case was approvable when you filed it. That means Not that, well, here's 200,000 and I think I'll eventually sell my property and I'll have some more money. Well, that's not approval when filed. You didn't have, the 600, the extra 600,000 when you filed the case. If you have a situation where you can prove the person had the 800,000 when he filed, he made a down payment on the 800,000, and he has an irrevocable commitment in writing to complete the rest of the 800,000, and he can document the lawful source of the rest of the money, then it can be filed. But there are a lot of ifs in there. And so we generally don't encourage it because it adds to the risk of problems in the case. But if we have somebody who meets all of those criteria, it may be possible to do it with less than 100% of the investment funds up front.
I mean, that makes sense. I like to say that please don't ask me if I'll take 100,000, because think of the adjudicator and what he's going to say about your petition when he sees that amount, and that usually brings up a good thought process. And
if you want your case to go through without issues and without problems, it's best to do 100% of the investment up front.
And we all know leveraging your funds is a great idea, but in this case, maybe not so much, right? Just to do it outright really helps. I have somebody would like to know the EAD and travel permit approvals. How long are they? Are you seeing them? How long are they taking? And if you I guess if you travel before you have the permit, does it get canceled? Is what their question is.
Sure. So first of all, as I've said before on our chat so far, anything about processing times, you do not set your watch by. It is not certain and it changes. Right now, we're generally seeing maybe 3 to 5 months on the employment authorization document approval from the time of filing the I-485, and maybe 6 or 7 to 10 months or so on the advanced parole travel document, with a few outliers taking much longer than that. In terms of leaving before, so if you're on an H-1B or an L-1 visa, then you don't need to wait at all for the travel document, and you're free to travel with your H or your L. If you're not on an H-1B or an H or an L, then your travel will result in the abandonment, the termination of your I-485. And in most cases, then you're going to have to process the immigrant visa at the U.S. consulate outside of the U.S. So the short answer is leaving before the advanced parole is approved, fine if you're on an H or L, not fine if you're not.
That's a great answer. I'm going to break up this question in two. I think I would like you to clarify that there's really no relationship between approval of I-526E and 485, which is the concurrent filing for adjustment of status. If you can talk a little bit about it.
Sure. So you're right. There is no relationship there. The I-526E is 100% about the project and about the source of funds, but nothing to do with your history. Do you have a criminal problem? Have you violated the immigration laws? Those are I-485 kinds of issues. A lot of biographic information, biometrics, and that's where you bring in your family members. So they're completely different things. Immigration cannot adjudicate the I-485 until they first adjudicate the I-526E. After they do that, they can adjudicate the I-485 anytime they get to it. But the issues on the I-485 are completely different. They're all issues personal to the investor, not relating to EB-5.
Thank you, Ron. This is an interesting question. You will love this. Can an EB-5 be withdrawn after filed? in case your EB-2, EB-3 becomes current.
Yeah, the answer is yes. Anybody can withdraw any petition that they have filed. Yes.
But there is a process, right, Ron? It takes a while.
Not exactly, because under the regulations, a withdrawal is considered effective the minute it's filed. So it doesn't need an adjudication. You're not waiting for an approval of the withdrawal. The minute the withdrawal is received, it's considered effective. And usually you'll get some acknowledgement that we acknowledge you withdrew, but you don't even need that.
Okay, that's good to. And then I do want to add this piece though, that the disinvestment of your funds or the return of your funds would be as per the offering documents, and it's specific to every project and regional center that you've invested with. I do want.
It's actually a very important point because people get confused by that. So the immigration laws, EB-5 laws, tell you that if you want to get your green card, you can't. There's a point at which you can't withdraw your investment. You must sustain your investment for a certain period of time. If you don't, you won't get your green card. So that creates the minimum. But in the end, this is a contract. If you're an investor and you're investing in a project and you're getting a private placement memorandum that's going to be telling you in great detail what the terms of the redemption of your investment are, that's what governs. So even though, and we've seen now that the Immigration Service has said that the sustainment period is shorter. And there's a lot of issues about what that means. But the bottom line is, even if the sustainment period is done, and as far as your EB-5 case is concerned, you can get your money back. That doesn't tell you when you're actually going to get your money back, because that depends on what the project documents and the private placement memorandum says.
Thank you, Ron. And there is my next question. And I was just going to tell you this, as I told you earlier, I'm such a fan of your article. Everybody on the call today, please let me know, and I will email you the link to this article. But here we hear it from Ron again. So the question is, there is so much confusion about the sustainment period. That could you give your perspective? Just, we have about 20 minutes, so if you could talk about it, it would be great.
You don't need to use the full 20 minutes, Ron, but I know that you could.
I wasn't planning on it. But thank you, John. So folks, this is actually pretty complicated, and it's difficult decisions that investors need to make. So the Immigration Service came out with a memorandum and said, we decided that now the sustainment period, the minimum sustainment period, is 2 years. And that sounds great, but there are a lot of problems with this. Number one is, folks, I've been doing EB-5 for over 30 years, and I've seen a lot. And I've seen what I call the bright and shiny object, where something seems great and everybody rushes at it, and then things fall apart. And I don't want my clients in that situation. So what's the problem here? Number one is the Immigration Service changed the law by a policy memo, which is not the legal way of doing something. And if you read it, they even admit they can change their mind. And we've seen this before. They could say, well, today we decided we think it's 2 years, but then 3 years from now, we said, no, we think we interpreted it wrong, it's 5 years. So that's a problem. Number two is, when they did that, they did not change the regulation. So the regulation is the law. A policy memo is simply policy. It's not the law. I know this is confusing. The regulation said before that the sustainment period is when you've completed your 2 years of conditional permanent resident status. That's still the regulation. They didn't change it. So as I explain to my clients, are you going to follow the law, which is the regulation, or are you going to follow the policy manual, which could be changed? The next issue is 2 years isn't 2 years. That's not being cute. That's being realistic. Why do I say that? Because when does 2 years start? 2 years doesn't start the minute you make your investment. You make your investment in what's called the NCE. I think most people listening know what that means. That's the investment enterprise. The 2 years doesn't start when you invest in the NCE. The 2 years start when the NCE sends the money to the JCE, to the job creating entity, which can be the same, but is usually different. And it may be that the 2 years doesn't start until the JCE actually uses the money on the project. It's not at all unusual that when investors invest in the NCE, the developer doesn't need all the money the same day. And so there's what's called drawdown schedules. We want 5 million now, and we want 5 million in 3 weeks, and we want 5 million in 2 months. And so the investor's money gets to the JCE at different times. Until it gets there, the 2 years doesn't start. And there's no real good mechanism for the investor to know when his or her money actually gets to the JCE to start the 2 years. When does the 2 years end? Well, it's 2 years after that gets to the JCE, but only if the necessary jobs for that investor have been created by that time. And projects have economic reports showing when all the jobs for all the investors have been created, but most projects do not have something investor by investor showing when the jobs for that investor were created. So I'm not trying to overly complicate this, and maybe what I just said is a lot to handle, but the bottom line is that you have to tread pretty carefully with advice from your lawyer on this 2 years, and make sure your lawyer is comfortable that whatever you're investing in seems to be okay meeting the sustainment period. Again, I hope that wasn't too complex.
It does sound like USCIS owes us in the industry a bit more guidance on this subject.
I think that's fair to say, John. Yeah.
I think they should have done that before increasing the fees. They owed us that much at least.
I think they should have done that instead of increasing the fees, not before they increased the fees.
Exactly. Ron, I know I had heard that there was going to be some litigation forcing USCIS to provide us with clear guidance. Are you aware of any? Is that still happening?
Yeah, all I can say there is I expect there will probably be litigation. I'm not going to be the lawyer on the litigation, but I would expect that might happen.
Okay. We are almost at about 45 minutes, and I promised Ron he could enjoy a lovely evening. So if we don't have any more questions, I'm going to check one more time. I want to thank Ron very much personally and on behalf of LCR Capital for the great work he's done for us on our projects, and for being with us and being in the industry, always providing us with guidance. Thank you very much. Thank you, John, for obliging me with this. And I just wish everybody the best. May you all make the right decisions about your projects, and just call us when we are happy to help. Thank you.
Thank
Thank you,
you.
Judd.
Bye.
Great session. Thank you, Ron. Enjoy a good weekend, everyone.